Alright, Bill Henshaw here again with current events that you will not at this point have seen on the internet, but you might soon. I've got a red hot case in Oakland where I'm helping out a new friend of mine over there, and we went over this past Monday to the office of the clerk of court and the office of the DA, conveniently in the same building. And we went over there trying to get documents filed for my friend's son who's in jail to be able to put on a defense, which he's entitled to do. And we got an agreement in principle to do that, amazingly. My friend has to go back once we get our documents, up to 100% speed here, which we don't have yet, but we'll probably go over next Monday and do that. And when that happens and we get a hearing date, now our issues are going to be before the quote-unquote judge, and they're going to have to make a ruling on the record, which is the last thing they want to do, because what we're saying with a lot of authority is you don't have any jurisdiction, and they almost certainly don't have any in your cases either. Even if you would have committed a common law crime and you had a real injured party, it doesn't matter. And again, we say with authority. I've got a case, this one doesn't come from the 904 to the U.S. Supreme Court, but I got a court saying at the turn of the century, 1900, in dismissing an indictment for murder, for crying out loud, that the judge said that it's unfortunate that a murderer should go unwhipped of justice, but more unfortunate that a court without jurisdiction should exercise it. Case is called Tully, T-U-L-L-I, versus United States, 140 Federal Reporter, page 899, and this section is on page 905. And you read that. In fact, if you want a copy of that case, send me an email at youwinnincourt@gmail.com. I'll send you that case and information on my constitutional defense document packets, too. And you can learn what it is I know and how to go in there and shake these bastards up and go in there and assert rights like they've never seen happen before. They won't know what to do with you either. So in any case, after a protracted discussion, and it was a friendly one for the most part with the clerk of court, we got an agreement in principle. Friend's going to go back, and she'll probably be going back with 800 pages from my materials that I just explained to you, the CDDP, with 570 odd jury instructions to get filed there. And that may make them quit even in a quote-unquote felony case. Because if they have to confront those, if you don't know, people, jury instructions are a very fertile area for a judge, quote-unquote, to commit reversible error. If they won't allow us to put on a defense and present our theory of the case to a jury, and the jury in this case has the power to rule on the facts and the law, the Constitution mandates it, the Supreme Court recognizes it. We have the power to do that. And we can beat them on jurisdiction every time out. I've been undefeated over the course of going into 5 decades here. They don't even respond to these pleadings because they don't know what to do with them. So that's how good that this is. But that said, we'll get documents filed, and I'll give you an update in this case next time we do videos. Now, we then proceeded to go to the office of the DA up at the 9th floor. And that's a locked office, by the way. You just can't walk in that office, which I would have loved to have done. But we talked to some subordinate personnel, and we presented them copies of paperwork that I had sent there, my own letter to the DA, and a letter I had sent to the county clerk. And out here in California, the county clerk, if you read our original Constitution, is required to be an elected position, and the clerk is ex officio clerk of the district court, a constitutional common law court. Not like the court where the clerk of court is down below on the first floor. That's a statutory court only. These common law courts are required to exist in states. And our original Constitution says it much. I would urge you to check those constitutions too, especially if you live in a state admitted before 1860. That would include all states up to Minnesota, February 14th, 1859. Check the original constitutions, because these courts have to be there. And originally, by the way, most of the federal questions were done in state courts. That was a compromise that was made, when the Constitution went into effect. And it was still in effect up until the ratification, quote-unquote, of the non-existent 14th War Amendment, where they started to take away most of this jurisdiction and require you to go into a federal court, which at the time, to be sure, in the 19th century, there were judicial courts. They're not anymore. All of them are, on the federal level, they're all territorial tribunals, and I can prove all of that. So we don't have a judicial court there. Therefore, if we have states, and the crown jewel of my unopposed arguments is we don't have any, and this is one reason, if we have states and we don't have judicial courts where we can go in and challenge the constitutionality of the acts of the legislature, we've got nothing. As I've said often, we're in a democracy, which is better known as a lynch mob rule, and it's majority rule, not a damn thing you can do about it. That's not how the nation and republic was set up. And these are the types of points I was trying to make with the clerk of court and the DA and get their attention and say, hey, you've got some real problems here. What I should have said, and I will the next time if I go to the DA's office, is the problem you have is if we win the case on the merits here, that's going to clean out the Santa Rita Hilton, otherwise known as the Alameda County Jail, because everybody in there can make the same arguments. You've got no jurisdiction. That's the magnitude of the issues involved here. So we have some work to do there. But for the most part, I was happy. And by the way, one thing I did do, and I didn't do this with the DA, but I went with the clerk of court and I told him how serious this was, and I gave him a document, and the title of it is Federal Criminal Complaint, Treason to the Constitution. So it says, you're keeping my friend from being able to invoke jurisdiction the Constitution mandates must exist, and at one and the same time, you're actively aiding and abetting a court to exercise jurisdiction it does not have. The Supreme Court, and it's them saying it, not me, has said in a very important case called Cohen's v. Case of Cohen's v. Virginia, 6 Wheaton 264, page 403, that for a court to exercise jurisdiction it doesn't have, or to fail to exercise jurisdiction it does, the one or the other is treason to the Constitution. This is not me saying it. And if you want a copy of that case, I'll be happy to send it to you. Send me an email, unincourt@gmail.com, and I'll send you the information, as I said earlier, on my materials, and help you get up to speed where you can do the same things I'm doing. It really isn't that complicated, because the amount of ignorance on the other side is astounding. Whether it's planned, I don't know, even law school graduates. And as I say in some of my paperwork, for goodness sake, a lot of the issues are so simple that a classroom full of fourth graders are going to readily understand it. And yet college graduates have had 4 or 6 years of law school don't? What the hell kind of a government is this we're running here? In any event, this Oakland case, and by the way, you may see this one, especially locally here, pop up on the radar, because the underlying motif here is that flaming white supremacist goes in and stands up for black defendant. When's the last time you've ever seen something like that happen? And the point I'm trying to make here is what we have to do is work together and not allow them to continue divide and conquer, which they've been doing for at least 150 years. And in fact, that's exactly what I'm trying to do with the clerk of court and the county clerk, divide and conquer, because they're the responsible parties. The real responsible party here is the governor, who's failed to perform his duty to see the laws are faithfully executed. But like I'm going to tell them, do you really expect the governor to say, if we filed a suit against you, oh, don't worry about it, take him off there, it's my fault, I did it? Are they going to say that? Hell no, they're not. They're going to let you go to jail and not care about it. That's the kind of power we have. We can get them to do not only what it is we want them to do, but the discretionless ministerial duty that they have. And now we got them over the ropes because they can't answer any of our jurisdiction arguments. They're going to have to dismiss the case. Simple as that. That said, remember, like my videos, tell your friends, subscribe, and see you next time. Thank you.